Manufacturing Innovation Survey. What may be the possible questions from this one? I can give you the question paper before this article explanation, but you may get confused because of various questions set by each article. Set from each article only. Let me come to this one. Which of the following statements about National Manufacturing Innovation Survey 2021-22 survey is correct? This is a basic model of question that may be possible. Like a statement-based question without elimination. Of statement 1 and 2, like assertion and reasoning. From this article only, like National Manufacturing Innovation Survey 2021 and 22 study evaluated the innovation process outcomes and barriers and manufacturing firms. You haven't known anything about it, isn't it? You haven't read it, but still you should be able to draw some inference to make this question correct. You should be able to do something, right? Because 75 to 80% of the questions are not known to most of the serious aspirants in the original exam. Ultimately, it is not possible for anybody. It is the maximum possible number of questions that confidently an aspirant can attempt are not more than 25 MCQs for last 3 to 4 years of the paper if you observe. So, let's come to this conclusion. How can you answer this question? This is National Manufacturing Innovation Survey. Instead of typing everything, just I have given shortcut. Study evaluated the, by default, National Manufacturing Innovation Survey it is showing. National Manufacturing Innovation Survey. So, this innovation, the term itself is providing an opportunity to make this assertion as right. There may be possibility that assertion may be right. And next, reasoning is, the study is follow-up of DST's first National Innovation Survey held in 2011. This is a little difficult one, whether it is a follow-up or not. Here you need some value addition and confidence. Suppose you are not able to remember after reading all the current affairs for last 1 year PTs, okay? Still, you have an option. You have an option that you will not be having fear factor because of the completion of all the topics that were covered last 1 year. So, you will reduce your fear factor after revising and reading all the components that were discussed. You may eliminate some kind of fear factor here. And next thing is about which of the following statements about National Manufacturing Innovation Survey 2021 survey is correct. This is providing you an opportunity to eliminate at least 1 or 2 statements. But still, there is no possibility for you nowadays in the UPSC examination. There is no elimination, as you have known. So, what is the possible, probable combination of options that may be possible to be correct, right? Suppose there are permutations and combinations. How many of the statements can be possible to be correct? How many of the statements cannot be possible to be correct? The possibilities, what is probability? Number of possibilities out of impossibilities. Okay, if there is 1% impossibility, you should not opt that one. If there is at least 1% impossibility, you should never opt that statement. Okay, so that is the basic fundamental idea. Let's come to this application. You may not, at least you cannot eliminate, you may not be knowing each and every statement given in here. You may not be knowing each and every statement given in the MCQ. But you should be able to draw 50% of the statement whether correct or wrong. That may fetch you to draw at least 4 to 5 questions out of 10 questions. And 2 may be wrong and 3 may be right. This is actual scenario of most of the serious aspirants. Therefore, they may be able to be in the edge between 85 to 90. So, coming to this basic logical technique, applying this basic logical technique, I think everybody is following me, right? Okay. National Manufacturing Innovation Survey study evaluated the innovation processes, outcomes and barriers in manufacturing firms. Is there any dispute with respect to this statement? It appears to be possible one, right? Is there any chance of impossibility in the given statement here? You don't know anything, because ultimately you might have read hundreds of books. It is not possible for you to get at least 10 MCQs out of those 100 books. This is the fact. So, what is actually the examiner judging and discussing here? So, based on your PYQ's ability, you may be able to attempt at least 10 questions. Based on your foundation and basics from NCERTs, you will be able to attempt 10 to 15 questions. So, 25 questions you will be attempting confidently. And remaining 75 questions that you need to apply your spontaneity, originality in the examination hall. So remaining 75 questions, checking and determining, actually validating your capability, your brain's equanimity ability, your stability, right? So how stable, how confident, how peaceful and composed you are while attempting the question and assuming whether the statement is correct or wrong. Let me come to the statement. The probability of making the statement is 100%. Looking to be, appears to be 100%, isn't it? Yes, the first statement is not giving you any kind of dispute whether to make it correct or not. And second statement, coming to this second statement, the National Manufacturing Innovation Survey focus solely, I am repeating, National Manufacturing Innovation Survey focus solely on the innovation ecosystem affecting the innovation outcomes. Is there any chance of 0.001% of impossibility from this statement? Yes. If I have given you one trick that if there is at least 0.0001% of impossibility in the given statement, you can, yes, maximum you can make it incorrect. At most of the cases, the probability is 90% to make it incorrect. Okay, to assume it as incorrect, the probability. So, National Manufacturing Innovation Survey focus solely on the innovation ecosystem affecting the innovation outcomes. So, eliminating the second statement is probable one, the probability. Out of the available choices, 100% it may be eliminated and it may be chosen at least 99%. See, the probability to choose may not be 100%, but probability to eliminate may be 100%. Are you getting what I am saying? Probability to eliminate a statement is absolutely 100%, but probability to choose a statement whether correct or wrong is only not more than 99%. With your assumption, you cannot make each and you cannot assume that the statement will be 100% right. Only based on your assumption, you cannot conclude that this statement will be 100% right. Only based on your assumption. But based on your assumptions and inferences and corollaries that are asked in CSAT paper actually, these terms, but these should be applied, the skills should be applied in GS1 as well for unknown questions. So based on your inference and assumption and corollary, the option which is going to be wrong is mostly correct, okay, from your side. So if you feel that this option may not work out in most of the cases, at least in one case, in one aspect, this option may not be correct. Therefore, you can comfortably eliminate that one. This is an option here. So, National Manufacturing Innovation Survey focus solely on the innovation ecosystem affecting innovation outcomes is having a chance of making it incorrect, right? This may be incorrect statement. So, you can eliminate that one. So, Karnataka had the highest share of innovative firms at 46 point some change. So, in the original exams, they will not torture you that much. Okay. In figures, in original exams, if you observe 41 years of UPSC question paper, for example, 2016 paper, I am referring 2016 question paper. In 2016 paper, what did they do? $1,000 billion per annum is the mandatory amount to be paid by developed countries to the developing countries under Kyoto Protocol. Per annum, the number was mentioned as 1000. Instead of 100, they have mentioned 100. So very simple. Then that 10 is making you that statement is correct or incorrect. Simple. Actually, it is $100 billion. So likewise, 99.9%, the figures and facts, exact figures, are not given correct in UPSC 40 years of papers. In most of the cases, if you observe the trend, I have referred one question in 2016. Similar questions, if you observe the trends, academic trends, increased growth rate and imports or exports, something else. When they ask you the exact figure, there may be a possibility of making it incorrect. So they will not torture you like me here, which I am giving you the statement. Okay, in the original exam. So making it incorrect in the original exam, there may be a possibility of making it incorrect in most of the cases by observing the trends of UPSC. But ultimately you need to take risk. You cannot attempt only 25 questions in the original exam. You should be able to attempt at least 80 to 85% of the questions. at least you must be able to attempt 80 questions with complete presence of mind and composed mindset in the original exam. So, the possibility of making it incorrect. First statement is correct, second, third may be incorrect. Likewise, if you assume. Next, the National Manufacturing Innovation Survey 21-22 is the first innovation survey conducted by Department of Science and Technology. National Manufacturing Innovation Survey, Innovation something, DST, Department of Science and Technology, some relation may be there. There may be some relation. Okay. So, out of these statements, 2 are from your part, 2 are confirmed. So, coming to this actual article, instead of directly discussing the article, I am showing the MCQs. So, you should be able to develop your skills, whether the statement is correct or not. You have to solve yourself. After that, you have to read the article. This is a basic reverse engineering technique. This will help you to align your mind while reading the article according to the lens of the UPSC. You will be seeing each and every article through the lens of the UPSC. Okay. For that, you need to see the MCQ first. Therefore, your mind will be directed to see the article through the lens. Coming to this article, what is this article talking? This National Manufacturing Innovation Survey, a joint study by the Department of Science and Technology and United Nations Industrial Development Organization. So, you need to know 2 things again. What is DST? What is UNIDO? The Department of Science and Technology, it is under ministry, one of the departments. That is fine, no problem. UNIDO is United Nations Industrial Development Organization, which is mandated to support developing countries for their industrial growth. Basic function. And it's headquartered in Vienna, capital of Austria in Europe. And there are permanent countries, 60 countries. And also, by this time, there are around 170 countries members of this UNIDO, United Nations Industrial Development Organization. Likewise, when you see something related to newspaper, some organization, international organization, you need to immediately learn there. Itself you have to finish. There itself you must complete the international organization. Now you have known about international organization, that is UNIDO. Its headquarters is in Vienna. Our permanent presence in our 60 countries. And next, UNIDO was established in 1966 by the UN General Assembly. UN General Assembly established this UNIDO, United Nations Industrial Development Organization, to accelerate for industrial growth in which countries? Developed countries. So, as of now, around 170 members are there in UNIDO. This is about international organization. So, this is actually being part of National Manufacturing Innovation Survey, DST, in collaboration with DST. So, these are the only things that you need to learn for preliminary examination from this article. Remaining things that the article, suppose Karnataka is the topmost one, and next followed by Telangana and Tamil Nadu. And least performing states here are always Odisha, Bihar, Jharkhand. Okay, this is the only thing that you need to learn from this article. Remaining elements are not required. Likewise, you need to go through other article as well. The article is talking about divorce can be granted on grounds of irretrievable or irretrievable breakdown. That is Supreme Court. Supreme Court is talking about issue of divorce. Okay. Here from this article, you need to learn about Article 142. What is meant by Article 140? It was used several times. Even in the case of Ayodhya also, this Article 142 was used to do complete justice. Supreme Court may go beyond certain constitutional norms to do complete justice. Not only the procedure established, but also due process and also certain natural principles to do justice. Okay, universal principles of natural justice. It may consider various other aspects also to do complete justice under Article 142. This is a fundamental theme, understanding about Article 142 from this one. By using this Article 142, if people in a relationship are extremely under suffering, they can comfortably break down. They need to wait for a local verdict, the local judgment which may come after 1.5 years. Okay, if their relationship is extremely strainful and it may lead to some kind of cruelty, okay, therefore they may immediately break their relationship. That is known to be irretrievable breakdown of marital relationship. So by doing this complete justice, however, it should be very cautious in nature. That was also reiterated by Supreme Court. Very simple. So what may be the possible questions from this article? What may be the possible number of permutations and combinations from this article? Assertion reasoning, statement 1, statement 2, okay, regarding article 142, or regarding the recent judgment. Okay, let's come to one type of question from this article. What extraordinary power does the Supreme Court have under article 142 of the Constitution? As I have mixed both these concepts, that is article 142 and also the judgment related to it. Here, what extraordinary power does the Supreme Court have under article 142 with respect to highlighting the recent judgment, that is irretrievable breakdown of marriage. Here, there are 4 statements which are lengthy in nature. You need to focus very exactly with conceptual clarity. You must have some conceptual understanding. Like example, last year they have asked a question related to prisons. Okay, under which list, that is also fine. But after deriving some inference from statement 1, you can make statement 2 as substantiating 1 to the statement 1, and both are true, and 1 is substantiating others. Okay, so likewise you need to have some conceptual understanding with respect to fundamentals and basics of the Constitution, that is article 142, and that is federalism and concepts related to it. Okay, next coming to this one. See, the power to grant divorce by natural consent without following procedural requirements. Whether option 1, that is statement 1, option 1, here option 1 only 4 options are given directly. The power to grant divorce by mutual consent without following procedural requirements. Without following procedural requirement. Is it making any sense? Please read it thoroughly. Without following any procedural requirements, the power to grant divorce by mutual consent. Let me read other statement as well, because you cannot conclude by one reading only. Okay, by one statement. So the power to, this is also one of the important techniques that you need to remember. Irrespective of vague or arbitrary statement given in the first option itself, irrespective of very vague arbitrary option given in the first instance, you need to read entire question. You should never jump into the conclusion immediately. Are you getting my point? So the first statement may be absolutely absurd. You cannot conclude, you cannot say that the statement may be possible to be correct. Still, you have to read entire question. The question here, you need to read. The first statement appears to be very absurd, because without following any procedural requirements, with the mutual consent, they can go for divorce. That is the option here. Still, you cannot conclude that this option is incorrect. Maybe, possibility out of. And third trick that I am going to tell you is, you need to choose best relevant option among the given relevant options, especially in the CSAT comprehension part. You must choose the most relevant option among given similar relevant options there. That is also very important. Okay, next coming to this one. The power to grant divorce by mutual consent without following procedural requirements. The first statement, whether it is correct or not, but your mind is saying that there may be a logical sense this question, this option may be incorrect. Okay. Next, the power to quash pending criminal or legal proceedings related to domestic violence or dowry. The power to quash pending criminal or legal proceedings related to domestic violence or dowry, because it was also given in the article. Therefore, that is why I have chosen this statement. The article, because there is huge pendency of cases in the Supreme Court and High Court, especially with respect to criminal cases as well, not only civil cases, but because of conversion of these civil cases into criminal cases. Every dowry act is becoming criminal again. So, because 498 is coming into picture. So, when many cases are under pendency, therefore, Supreme Court is to reduce such a pendency of cases, which is taking 1.5 years, 2 years time to mutual consent, divorce for the cases related to divorce with mutual consent. Therefore, Supreme Court is using this Article 142 to do complete justice. What is this Article 142? It can go beyond the constitutional norms to do complete justice to both the parties, okay, by using due process of law and also basic fundamental principles of natural justice, right? So coming to this one, this is also given in the article, but you cannot conclude that this is the right option. And next, the power to establish and constitute the Supreme Court. The power to establish and constitute the Supreme Court. It is very vague compared to first one. The power to review any of its judgments or orders. The power to review any of its judgment or orders. See, to do complete justice, it may consider anything. It can also review under various other judgments also, not only under Article 142. It can use Article 139 Court of Records. Okay. So it is not a complete relevant option. Article 142 can use anything. Okay. Even judge's conscience can also come into picture while using that Article 142 to do complete justice. A judge may feel that he is not guilty. He may give some chance, or he may do some justice, and something is not proven yet. Okay. So this may be possible, but this is not relevant with respect to irretrievable breakdown of marriage in the recent judgment. What is the question here? Article 142 may be possible with respect to fourth option, but with respect to, as highlighted in a recent judgment on irretrievable breakdown of marriage, with respect to this recent judgment, the fourth option is not relevant, isn't it? Only with respect to Article 142, Supreme Court can go for various other options. It can review its own judgment to do complete justice, naturally, right? But with respect to this particular highlighted one, you cannot conclude that fourth option is correct. You cannot say the third option is very vague. And second option, quash pending criminal legal proceedings. For that purpose, it hasn't taken, because under Article 142, what is the highest priority of the Supreme Court while using Article 142? To do justice to both the parties, to do holistically to every party, all the stakeholders. Okay, it is not for the purpose of reducing pendency of the cases. That is inevitable or consequential effect out of this decision. That is not the primary motive of the Supreme Court while using this Article 142 as highlighted in the recent judgment, that is irretrievable breakdown of marriage. With respect to that judgment, Supreme Court's highest priority is not about reducing pendency of cases. Its highest priority. Okay. The power to grant divorce by mutual consent without following procedural requirements. Now you have understood. Choosing most relevant option among given relevant ones. In the first instance, please tell me, everybody, you might have understood this. In the first instance, while reading option A, what was your opinion? Without following basic procedural norms as procedure established by law. Procedural norms means procedure established by law. Without following these procedures established by law, you can take divorce with mutual consent. This was the first statement. Without following procedure that was established by law. Under Article 142, that was Supreme Court statement, means inference. But in the first instance, while reading the option A, what is your feeling? This is not a possible one, because how can you take divorce directly without following basic procedures established? There are many laws, Hindu Marriage Act, and the Civil Procedure Act, something else there. So without following procedure, but when you come to this option B, C, D, what will be the final conclusion? Option A should be the right one. Okay. Remaining options may be relevant to Article 142, but not with respect to the recent judgment. Are you getting what I am saying? So this is an extra edge for an aspirant who is very composed in the examination hall, who is very smart and comfortable in understanding questions and solving many questions like this, who understood UPSC by reading various previous year questions and analyzing PYQs, how they are twisting these statements, who is very composed and calm, comfortable in the examination hall. They can quickly grasp what is relevant option, what is the probable option that is going to be correct 100%, that is not going to be correct 100%. Okay. By analyzing holistically in 360 degrees, each and every option, you are concluding the relatively less arbitrary statement is the correct one. Ultimately, option A appears to be arbitrary one in the initial stage, but relatively it is less arbitrary compared to one or more relevant compared to other relevant options. Are you getting what I am saying? Right. So likewise, without knowing anything regarding the irretrievable something marriage, divorce, ఏదో కొట్టుకుంటున్నారు చచ్చిపోతున్నారు అని మనకు తెలియదు. ఇర్రెస్పెక్టివ్ ఆఫ్ దట్ అయినా కూడా నువ్వు కరెక్ట్ చేయగలుగుతున్నావు, అవునా కదా? సో ఇప్పుడు మళ్ళీ ఇక్కడ వెళ్దాం. సుప్రీం కోర్ట్స్ ఎక్స్ట్రాడినరీ డిస్క్రిషన్ అండర్ ఆర్టికల్ 142 ఆఫ్ ద కాన్స్టిట్యూషన్. Article 140 of the Constitution can be used to grant divorce by mutual consent, sparing couples misery of waiting for local courts to declare annulment final. So, suppose, just use my sense, that instead of giving the question and explanation, I have taken the direct statements, and here itself I am discussing whether this statement is correct or wrong, because there is no option for you to eliminate here. I have given 7 statements. How many of the above statements are correct here? I am asking. So why should I frame a complete question here? I have to give 7 statements. You have to tell me which is right statement or wrong statement here itself. Okay. So the Supreme Court's extraordinary discretion under Article 142 of the Constitution, which can be used to grant divorce by mutual consent, sparing couples the misery of waiting for local courts to declare annulment, is final one. Whether the statement is correct or wrong, because already we have discussed, so you can comfortably tell this is the correct statement. Okay. Next, coming to the second statement, I will not display whether it is correct or wrong here. After your observation only, I will display. The same extraordinary power can be used by the court to quash pending criminal or legal proceedings related to domestic violence or dowry against either party. The same extraordinary power. What is that same extraordinary power? With respect to Article 142. Extraordinary power can be used by the court to quash pending criminal or legal proceedings related to domestic violence or dowry against either party. Can be. And fourth trick that I am going to tell you here is, if any extraordinary thing come into picture and any possibility given in the option, suppose extraordinary itself is beyond certain threshold, and possibility term, possibility means maybe, can, directly they may ask you possible. Are you getting the keywords in the statement? Maybe, can, possible. ఈ స్టేట్మెంట్స్ లో మీకు ఇచ్చిన స్టేట్మెంట్స్ లో కెన్, మేబీ, పాసిబుల్ అనేవి అడిగాడు. పైగా అక్కడ అడుగుతుంది దేని గురించి? సంథింగ్ విచ్ ఈస్ బియాండ్ ఎక్స్ట్రాడినరీ సమ్ ఎలిమెంట్స్. సపోజ్ ఫ్యూచర్ లో స్పేస్ టెక్నాలజీ గురించి ఏదో జరగబోతుంది, ఆర్టిఫిషియల్ ఇంటెలిజెన్స్ మీద ఏదో జరగబోతుంది, ఇంటర్నెట్ ఆఫ్ థింగ్స్ గురించి ఏదో జరుగుతుంది, ఇంకా రీసెర్చ్ లో ఉన్నాము. బియాండ్ యువర్ అబ్జర్వేషన్ అండ్ రీసెర్చ్, డార్క్ మ్యాటర్ గురించి ఏదో అడిగాడు. బియాండ్ యువర్ అబ్జర్వేషన్ అండ్ రీసెర్చ్, కెన్, పాసిబిలిటీ, మేబీ అని వచ్చాయనుకోండి, దేర్ మే బి ఏ పాసిబిలిటీ ఆఫ్ చూసింగ్ దట్ స్టేట్మెంట్ ఈస్ కరెక్ట్. 99% మనకు వచ్చిన ట్రెండ్ లో, యూపీఎస్సీ ట్రెండ్, ఇఫ్ యూ అబ్జర్వ్ లాస్ట్ 41 years of యూపీఎస్సీ ట్రెండ్, దేర్ మే బి ఏ పాసిబిలిటీ ఆఫ్ చూసింగ్ దట్ స్టేట్మెంట్ ఈస్ కరెక్ట్. ఇజంట్ ఇట్? సి, జస్ట్ అజ్యూమ్, ఇంటర్నెట్ ఆఫ్ థింగ్స్ వల్ల మీకు ఏమేమి ప్రయోజనాలు ఉంటాయి? కెన్ యూ డిఫైన్ దీస్ ఆర్ ద ఓన్లీ బెనిఫిట్స్? కెన్ యూ కన్ఫైన్ దీస్ ఆర్ ద ఓన్లీ బెనిఫిట్స్? What are the number of possibilities? So the permutation or combination, if you draw permutation combination, the probability of available choices, out of available choices, there may be 100 options. So you have to choose that one. So Article 142, which is an extraordinary power given to the Supreme Court to do complete justice, and by using this article, if it feels that there is huge pendency of cases across the country, to reduce this pendency of cases, can I use this extraordinary power? Yes. Can I? I am asking. Can I? Yes. I must use ante wrong. I must use ante wrong. I should ante wrong. I can ante right. Terms అర్థమవుతున్నాయి కదా? ఇక్కడ టెక్నిక్స్ తోటి మనం కొట్టాలి. Right? The same extraordinary power can be used by the court to quash pending criminal or legal proceedings related to domestic violence or dowry against either party. Are you getting? Yes. So అక్కడ కరెక్ట్ అని ఇచ్చేసింది. Right. Next, coming to entire
entire law of divorce is built predominantly on assigning fault to one partner or the other. This is common sense. Next, fifth technique is about common sense. So basic గా డివోర్స్ కి వెళ్తున్నారంటే ఏంటి, బేసిక్ డివోర్స్ కి వెళ్తున్నారంటే అదొకే, బట్ ఇక్కడ ఆల్రెడీ దిస్ ఈస్ ద స్టేట్మెంట్ గివెన్ బై ద సుప్రీం కోర్ట్ ఇన్ ఇట్స్ రీసెంట్ జడ్జిమెంట్ ఓన్లీ. ఐఎమ్ టేకింగ్ దోస్ స్టేట్మెంట్స్, బట్ by having simple common sense, people who are in dispute, they may make allegations to each other, especially wife and husband. Without taking divorce also they make allegations to each other, right? General tendency. So it is very common. So the entire law of divorce is built predominantly on assigning fault to one partner or the other. Okay, this is statement given. Next, irretrievable breakdown of marriage is a recognized ground. Irretrievable breakdown of marriage is a recognized ground for divorce under the Hindu Marriage Act. Yes, under the Hindu Marriage Act only that statement was used. Why should I use breakup ane vaadachu kada nenu? Why should I unnecessarily noru dirakapoina irretrievable breakdown of marriage? Why should I use? Because it's legal term. This is a possible question, so the possible statement will be from this one only. So irretrievable breakdown of marriage is a recognized ground for divorce under a Hindu Marriage Act. Okay. Despite recent judgment, irretrievable breakdown of marriage is not at a ground for divorce under the Hindu Marriage Act. This term was mentioned in Hindu Marriage Act, but breakdown of marriage is not a ground for divorce. Okay, this statement, this legal term is part of Hindu Marriage Act. బట్ హిందూ మ్యారేజ్ యాక్ట్ నేను పట్టుకుంటే ఏమవుతుంది, నీకు మినిమం టైం ఎంత పడుతుంది, 18 months, 1 year to 18 months. సో ఇప్పుడు నేను దాన్ని లిబరలైజ్ చేసి నువ్వు డైరెక్ట్గా కోపం వస్తే కొట్టుకొని విడిపోండి, ఓకే, దానివల్ల నాకు పెండెన్సీ ఆఫ్ కేసెస్ తగ్గుతాయి. అందు గురించి నేను ఏం చేశాను, ఈ క్లాజ్ని నువ్వు యూజ్ చేసి లోకల్ కోర్ట్స్కి వెళ్ళక్కర్లా, డైరెక్ట్గా ఇద్దరు కలిసి మ్యూచువల్ కన్సెంట్తో వెళ్తా అంటే హిందూ మ్యారేజ్ యాక్ట్ కింద ఈ క్లాజ్ ని నువ్వు పట్టించుకోకుండా అంటే యూ కెన్ సబ్సైడ్ దిస్ క్లాస్. వాట్ ఈస్ దిస్ క్లాస్? ఇర్రిట్రీవబుల్ బ్రేక్ డౌన్ ఆఫ్ మ్యారేజ్ అండర్ హిందూ యాక్ట్. ఇఫ్ యూ గో అండర్ హిందూ యాక్ట్ ఇట్ విల్ టేక్ అరౌండ్ 18 months. అదే, సో దిస్ ఈస్ వన్. నెక్స్ట్, సో బేసిక్ అంటే దేర్ ఆర్ సర్టెన్ కామన్ సెన్స్ వన్, దేర్ ఆర్ ఫ్యాక్చువల్ వన్స్, దేర్ ఆర్ కాన్సెప్చువల్ వన్స్. ఓకే, టెక్నిక్స్ ఉంటాయి, మళ్ళీ ఇవన్నీ యూజ్ చేసి మల్టిపుల్ పర్ముటేషన్స్ కాంబినేషన్స్ తో ఈ స్టేట్మెంట్ రైట్ రాగానే మనం ఫైట్ చేసుకుంటూ వెళ్తే దేర్ మే బి పాసిబిలిటీ ఆఫ్ గెటింగ్ 90 score, 90, రైట్? నెక్స్ట్, ఇట్ ఈస్ పాసిబుల్ ఫర్ యూ టు అటెండ్ 95+ as well if you can complete all these 1200+ topics and also your basic static component. Okay, next, granting divorce by the Supreme Court based on irretrievable breakdown of marriage is an absolute right for the parties involved. Is it an absolute right? By default you can use, if I use must, if I use compulsory, if I use absolute, can I demand Supreme Court? So how can I say it is my absolute right? It is a choice given to you by the Supreme Court to reduce burden on itself and at the same time to make you free from very some disturbed relationship, strained relationship. That's it. So common sense. Article 124 of the Constitution establishes and constitutes the Supreme Court. Okay, and it doesn't establish Supreme Court. It only allows the Supreme Court, what do you call, with respect to recruitment. Ever Chief Justice, ever gaadu. Next, 137 in 136 special leave petition. 136 is about providing Supreme Court with the authority to review its own judgment. 139 court of record. 139. So these are basic articles. Why should I read these articles again? Because these were mentioned here, 124 and 131, 137 in the article. ఇవన్నీ కూడా యూజ్ చేసింది ఎవరు? సుప్రీం కోర్ట్ వైల్ గివింగ్ జడ్జిమెంట్ ఇన్ దిస్ ఇర్రిట్రీవబుల్ బ్రేక్ డౌన్ ఆఫ్ మ్యారేజ్ రిలేటెడ్ టర్మ్. ఓకే, అండర్ విచ్ ఆర్టికల్ Supreme Court considered various elements? Under which article? 142. So to do complete justice under 142, what does Supreme Court do? It can use other articles, it can use its conscience, it can use due process, it can use fundamental principles of natural justice. Okay. Next. Next article is about protection from arrest extended to central armed police deployed in Jammu, Kashmir and Ladakh. So what is this protection? It is protection given to whom? Not people. It is protection given to paramilitary forces. Not only the armed forces, but also paramilitary forces. What are paramilitary forces? CRPF, BSF, Assam Rifles, Coast Guard. These are paramilitary forces, right? And ITBP, Indo-Tibetan Border Police Force. These are part of paramilitary forces. Okay, Border Security Force, all are. So, the paramilitary forces which are deployed in the conflict zone across various borders of our country may be protected under civil CRPC action. Suppose this is section 45. What is this? Section 45. Center has extended protection from arrest. From arrest to whom? These paramilitary forces under section 45 of the Code of Criminal Procedure. To the personnel of the Central Armed Police Forces and all armed forces of the Union of India who are deployed in Union territories of Jammu and Kashmir, Ladakh region. Right? So, what may be the possible inference that you can draw with respect to UPSC? What were the questions asked previously with respect to detention? Okay, Unlawful Activities Prevention Act. With respect to this, what do you call? Prisons. Who will administer the prisons? Okay, Prisons Act. Okay, 1894. All these were asked by UPSC last year. Okay, so legal cases can still be registered against personnel. So, when a paramilitary a person who is a CRPF Jawan inquiring into any criminality of an individual, he will not be charged under this article, section 45 of this CRPC. Okay, he cannot be arrested. But he is trespassing into your territory. You have any personal rivalry, you can go for legal case. Are you getting? You can file a case against this person who is part of this paramilitary force deployed in the region of Jammu and Kashmir, but he is trespassing into your private premises under private grounds without having any legality behind it. Therefore, they can be charged, but it is very difficult to prove. That is also very important. So, what are the facts associated with it? So, previously, before abrogation of Article 370, what was the penal code followed in the Jammu and Kashmir region? Did they follow CRPC, CPC, civil procedure? No. So, one of the penal provisions that they had adopted, this was passed previously, before independence itself, in 1930s, 40s. So, the code was Ranbir Penal Code. Okay, before abrogation of Article 370, what was the code? Ranbir Penal Code. So, Ranbir Penal Code, which was applicable there, but after this one, what happened? After this one, what happened? Can somebody tell him to come inside once? Run out. Okay. So, this is Ranbir Penal Code, which was applicable before abrogation of Article 370. But later, the CRPC was induced, and this under CRPC, section 45, the armed persons, the armed forces, not only the armed forces, but also the paramilitary forces who are deployed in the Jammu and Kashmir region are protected from arrest. Okay. During, what happened? So, finally, this Criminal Procedure Code, commonly called as CRPC, is the main legislation which was administration or substantial criminal or something. It was enacted in 1973, which is not required actually with the lens of UPSC. So, CRPF that you have known, it is one of the paramilitary forces out of 7 forces: Indian Coast Guard, Indian Indo-Tibetan Border Police Force, Border Security Force, Assam Rifles. Okay, and these are part of SSB, paramilitary forces. Okay. So, what may be the possible question out of this one? Which of the following statements are correct regarding recent extension of protection from arrest under section 45 of Criminal Procedure Code. Two persons deployed in the region Jammu and Kashmir and Ladakh. Here, legal cases can still be registered against the person, but their arrest now requires following additional legal processes. Yes, if somebody is trespassing into my private premises, I can file a case against him. But he may be armed personnel who is deployed in Jammu and Kashmir region. He may not be prosecuted under section 45. No, there may be legal proceedings against him. You have to prove that he is not under duty and it is not part of his duty to enter into my private premise. You have to prove that one. So additional legal proceedings are required with respect to this person who is a paramilitary person. Are you getting? What is this additional legal proceeding? What is this additional legal? That you need to prove he is not concerned with his duty. He has his personal rivalry or something in conflict between us. So you need to prove that it is purely non-duty oriented, right? That one. Next, so additional legal process is required. Next, earlier this protection was applicable only to the armed forces. Earlier it was applicable to only armed forces. Now it is applicable to paramilitary forces as well. Next, the protection was previously applicable to J&K due to the Ranbir Penal Code under 1989. So the extension, why 1989 Ranbir Penal Code was amended? Because it came into picture in 1936, actually, before independence only. But it was amended in 1989. Because that illegal eviction of Pandits took place in 1989 itself. Therefore, so the paramilitary forces were deployed in the region of Jammu and Kashmir, and also conflict happened in various aspects, right? Next, the protection was previously applicable to Jammu and Kashmir due to, yes, Ranbir Penal Code. Next, the extension of protection. If I ask you any statement that under section 45 of Ranbir Penal Code, which is exclusively applicable to Jammu and Kashmir, the paramilitary forces are protected. If I ask you that question, then you can comfortably eliminate it. If you have read it based on your facts and analysis, you can make it correct or wrong. Okay. So I have given you various permutations and combinations of making one statement is correct or incorrect. Okay. Next, the extension of protection was proposed after the repeal of Article 370. Extension was proposed after repeal of Article 370 of the Constitution of India. Ministry of Home Affairs considered this proposal and also agreed to these proposals that this extension may be possible because of the recent conflicts that have been continued after abrogation of Article 370, and not only to this extension applicable to armed forces but also paramilitary forces under CRPC instead of Ranbir Penal Code. Next, as per CRPC section 45, no member of the armed forces of the Union can be arrested for actions done in discharge of official duties without consent of the central government. Yes. So it may appears to be very arbitrary, but when it comes to on POTA, TADA and UAPA, unlawful activities prevention act, something. So these cases, when they are dealing with these terms, so there may be certain terms which are arbitrary in nature. Recently in last year 2023 as well, they have asked the questions related to it, right? I'll tell you what are the questions though. I'll display them. India has operationalized this. Next, coming to fourth question, fourth or fifth article it seems. Next, India operationalizes Myanmar Sitwe port. Myanmar Sitwe port operationalizing. What is this Myanmar Sitwe? See here, Kaladan Multimodal Transit Transport Project. What is this multimodal term? Because it can use sea route, it can use naval route, it can use road and railway. It is a multimodal transit transport project, and it came into picture after an agreement between Indian side and also Myanmar side. And next, departure of the recent inaugural ship, that is from Shyam Prasad Mukherjee port in Kolkata. It can reduce the distance between Kolkata and Aizawl by about 1000 kilometers, because the pressure on Siliguri corridor will be reduced by incorporating this transit transport model, which is multimodal one, Kaladan multimodal. So, how will be the sea route here? Through sea route, you can do some journey 539 kilometers here from Kolkata, that is Shyam Prasad Mukherjee Port, to Sitwe, which is located in Myanmar. From Sitwe, it is Kaletwa. They are also part of Myanmar. After reaching the Kaletwa, you will be reaching this Mizoram, that is located, that the name is, the entry place is Jorinpui. And next, you will be going towards, after reaching this Langklai and Aizawl. Okay. Here, through Paletwa, from Sitwe to Paletwa, you will be using which mode of transport? No, here sea route you will be using. Here you have inland waters, and next you will be having railway route and road route. Okay, that is why it is called as transit multimodal project. So Myanmar. So it is an initiative part of Kaladan multimodal transit project. What are the key highlights in it? The port connects to Paletwa in Myanmar through an inland waterway from Paletwa to inland water. What I have said? Inland waterway. And from Paletwa to Jorinpui in Mizoram through a road component. Have you got what I have said? Okay. Port is connecting to Paletwa. That is naval route. Okay. In Myanmar, again through, you are catching inland waters. Through inland waters, you are reaching Paletwa. Paletwa to Jorinpui. Jorinpui is located in Mizoram through road component. So, Kaladan multimodal transit transport project. Next, the port built under grant assistance from whom? Indian government. And it has been developed under framework agreement between India and Myanmar. Okay. And recently, in the first transit transport model from Kolkata to Sitwe, it has shipped around 20,000 bags containing 1,000 metric tons of cement. Okay. They are expected to reach Sitwe, already they have reached. So the port will open new opportunities for trade and transport are okay. That is about mains orientation. That is not required. Our fully operationalized this Kaladan multimodal transport transit project will provide alternate connectivity for the northeastern state, which can reduce some cargo traffic cost. Okay, these are the benefits. You can write benefits with respect to mains orientation. Next, Kaladan multimodal transit project is jointly identified by whom? India and Myanmar. So suppose if I ask you a question related to Kaladan multimodal project, if I ask you a question like Kaladan project aims to connect the Eastern Indian seaport of Kolkata with Sitwe seaport, Rakhine state. Yes, it is Rakhine state in which Arkaniyoma mountains are located. Okay, are extended here only. Next, Myanmar via sea. The Kaladan project focuses on creating a high-speed rail link between India and Myanmar. No. Next, the Kaladan project aims to establish a direct road connection between Kolkata and Mizoram. No, it is one of the components only. Next, Kaladan project is primarily funded by Ministry of Defence. Actually, Ministry of Defence is funding whom? BRO, Border Road Organization. Okay, Border Road Organization is funded by Ministry of Defence. So next, choose the correct statement. You no need to give option A, B, C, D because there is no chance for elimination now. Okay, you should prepare that there is no chance for elimination for 100 questions. Next. So it will reduce distance from Kolkata to Mizoram by approximately 1,000 kilometers, and travelling time will also be reduced here because 3 to 4 days for transport of goods. Next, Union government takes control of whom? Manipur security. You need to remember two things, that ethnic tribes and possible questions that I have identified already mentioned here. Ethnic tribes, legal provisions to protect their customary laws and practices and various constitutional safeguards given to them and related articles. Okay, so they will not ask you questions how many people were died in their conflict, right? Generally they don't ask. So but it is important. What is important here? Here, see the important constitutional safeguards and provisions and legal protection given to their customary practices, and next ethnic tribes located in that region and the major point of conflict between those ethnic tribes, right? Here, what is, and remaining all aspects are not required. Only thing required here is Article 350 of the Constitution. What is this Article 350 of the Constitution? The conflict arose in there. when the conflict was arisen, what was the immediate effect that government of India it has come into picture? What was the immediate effect that came into picture constitutionally as well? Article 355 first. Before imposing Article 356, that is presidential rule in the state, what should they consider? Article 355. Okay, they have to check whether this state is under constitutional machinery or not. Any internal disturbance is happening in the state, they have to check under Article 355. If Article 355 is supporting, then President rule can come into picture under Article 356 through a notification. Okay,